All right. There's a total amount of 2565 owing. Was there a method by which you were intending on getting this paid, or do you know?
I'm going to be very honest with you, Judge.
Okay.
I have no intention of paying one penny. No intention of paying one penny. I've been with Barnes and Barnes for since 2021 in this place. I've been with Barnes and Barnes for about 6 years now. Before that, I was in different apartments with Barnes and Barnes. Before that, I've been in EMU since I was 16. Eastern Police, Ipsy Police, all y'all have just failed me. I've been begging Barnes and Barnes to fix my house for a simple fan for heat in the winter. I'm having to take money out of my pockets to keep myself fed. I would rather sleep in my car than fight for a house. I'd rather win a settlement than fight for this and give my last tears and blood, sweat, and tears into this. My husband doesn't understand how to speak to me nicely. That's why we're not standing here together. And I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March I was in jail for beating him up. I'm not going to stand here and go out of my character and act irate when I don't want to fight for something that's mine. That's not he claims that it's his more than mine. I brought him into my house. I gave him my car. I gave him the clothes on his back. I'm not going to fight for this anymore. I'm exhausted, tired, and hopeless. Ipsy Police was in my house today at 5 a.m. when I asked for harassment. I filed a PPO. I'm getting no help. I'm hopeless, frustrated, and exhausted, and I'm done.
Okay. I just had to make sure, which is why I wanted it in the courtroom, that I was going to find no tribal issue. I was going to issue a judgment to the plaintiff. And I just wanted to make sure that you understood what the court was doing, which is why I wanted you here. All right. So the court finding no tribal issue on their judgment for possession and money. It looks like you requested for possession and money as to both defendants. Total amount, the 25,600, that was inclusive of cost, correct?
Yes.
In the total amount of $2,565. And an order of eviction or writ will issue in 10 days. All right. Thank you.
Sorry, could you say that again? I speak three different languages. I'm not American. I'm British. So I didn't understand one word that came out of your mouth. I'm sorry, sir.
The whole thing?
You're throwing legal words at me, sir. I'm mentally,
ma'am.
I'm in
All right.
middle school. I didn't pass, I
Okay.
speak three different languages. I'm not educated.
Okay.
So I don't understand when you throw legal terms at me. I need to speak to me like a toddler. I would understand that better. Thank you.
All right. I'm issuing a judgment. I'm signing a judgment, a piece of paper indicating that plaintiff, your landlord, has the right to possession of the premises.
Okay, so
unless $2,565 is paid prior to July 1st or by July 1st. If it's not paid by July 1st, they can then file for what's called a writ of restitution or an order of eviction to have you move. Either at that point you can move by then or you can pay the money by then. If you fail to move, what will end up happening if they file that order of eviction, the court will sign off on it. And then what will happen is the sheriff, another police agency, or the sheriff's department or a court officer will show up and will, if you haven't vacated the premises, will remove you from the premises.
yeah, and I know how the eviction process works. I just don't. I have lawyers in my family, but I'm more on the medical side rather than the lawyer side. But I appreciate all your help, and sorry,
All right.
my husband and I aren't cooperating today.
Thank you.
Thank you, Your Honor.
It was brought to the court's attention that the property was uninhabitable, using that term in a general sense, and that Ms. Childress and her two children should attempt to vacate the property sooner than the 30-day notice. And that's where we left it. I don't have any other information.
Okay, and I think we gave you the information to Hawk and other things. What happened?
Me and the kids are staying next door.
Pardon?
Me and my kids are staying next door with the neighbor. Um, my son's finishing out this week. And then my mom's getting me a truck. She couldn't get it until this week. So, I mean, by the end of the week, all the stuff should be out. I called Hawk, but their appointments are scheduled out until April. And then she emailed me a list of things to get a hold of. So,
Of places to get a hold of to do that. All right. So, Mr. Licky, you're out of the premises, is that correct?
For the most part, I was just staying there temporarily, just helping her pack. That's it. But I'm my mom pretty much. So
Okay. And your mom's getting you a truck. And then that's supposed to happen Friday, you said?
yeah, by this week. She
Right.
works, she's off Sundays and Mondays. So if I have to be able to get out there earlier in the day before she goes to work. So we're still trying to figure out which day is going to work for her, for me to get a ride down there to get the truck.
Okay. And so it's anticipated that at some point you're going to be out of the premises.
probably within about a week and a half. Yeah, everything should be out, removed
Week
completely.
and a half of today, from today, or
Yeah, from today, about a week and a half.
ma'am, do you agree with that timeline? You think so? So by the 23rd? And if the property is vacated by the 23rd, then you guys are not going to have an issue with it going back to the landlord.
No.
Okay. That actually may work then. If you can try to do it by the 22nd, it would be appreciated. But what I'm going to do is I'm going to then adjourn this matter to February 23rd. At what time of day? I'll just put them into a regular block.
And Your Honor, would you like to discuss the counterclaim and that sort of stuff today, or?
Yeah, let me get to that. 2 p.m. So it'll be February 23rd, 2024 at 2 p.m. All right. Now, as to the counterclaims that you have, what do you intend on doing with those?
I'd still like to pursue it because it's pretty serious still.
Okay, so let me ask you this. Since we're really at a final settlement conference stage, have you entered into any discussions with them about that?
I've had communications, but they don't really agree with any of it.
Well, let me ask this. Who owns the trailer?
Your Honor, the plaintiff owns the trailer and the land, the lot and the trailer.
Okay. So have you made any demand about what you want from them?
Yeah,
Is that correct, counsel?
I'm sorry, has he made a demand?
Yeah.
Well, he has filed an answer with a counterclaim, and attached, it's not in. There was an email which listed the money
Okay.
damages, and it essentially comprised one half I would call ruined property, and the other half would be kind of a tort claim, a claim saying that the plaintiff brought this moldy situation upon them, and it damaged him, Childress, and the two children, and made a prayer for relief of approximately $50,000. It's not, I don't know what the court's record looks like, but it was not listed in the, what I believe to be the filed supplemental answers to complaint, affirmative defenses, and counterclaim. I don't believe that there was a prayer for relief. Not a specific prayer for relief in that document.
Are there photos of these items you're claiming are damaged?
There's not photos of the specific items, but just from the mold specialist, he told us anything wood, stuffed animals, toys, plastics, anything that it was.
I understand that part. I'm just saying.
I don't have pictures of like the dresser and stuff like that. I mean, I have pictures of like the carpet and.
Let me ask you this. If I were to decide this, how do I know these items that you listed existed?
I mean, it's not really, I mean, it's really just like stuffed animals, toys, a dresser is like the only furniture
I
item.
understand what you're telling me. How do I know they existed?
I get you.
Okay, so we have an answer to that?
I mean, I could preside pictures on the return court date if needed, but yeah, I didn't know, I wasn't thinking on that part.
I mean, you've attached a value to these items.
Right.
How'd you come up with those values?
Pretty much I just went like on Craigslist, Facebook Marketplace, and it's very reasonable. I pretty much just got like the median of what it would cost to replace it. Like even a dresser, I've only claimed like $60. I mean, you can get a dresser for $60. I mean, I don't need, a $300 one or nothing like that.
Well, understand that if you're claiming that the plaintiff caused the damage, what you're going to be entitled to is really the value of the property destroyed. Okay. And so I think the thing you need to think about is this, that if you had a dresser that, let's say, is 10 years old, right? It's not going to have a whole lot of value to it, right?
Right.
Furniture typically doesn't have a whole lot of value once it's used. I see on your list that there's carpet. Well, was that a rug or was it carpeting that was down in the premises?
It's brand new carpet that we laid when we first moved in and the padding underneath. It was just in that one room.
Okay. So how many years has the carpet been there?
Probably just about a year.
How much did you pay for the carpet?
I don't have a receipt, but I attached a photo of the same carpet from.
I see it. But
it ran me probably about $400 ish.
What's the total amount you're asking for?
From the damage claims or the whole thing?
The whole thing.
It came out to about roughly like 48,000 ish.
And how much of that is damages?
Uh, I'd probably say about around 1,500 if I recall properly. I'm not 100%.
1,500 in damages. The rest of it is what?
Mainly pertains to health issues, the environment we were in. I mean, that it could have caused some serious issues. We were trying to get mold tested as well, but according to them, if the kids
Okay.
came,
Here's one of the things you're gonna have to look at. At some point, you know that mold is there, right?
correct,
And so at that point that you realize that there's something there, you can't just sit there.
oh no, once we noticed the mold, I mean, we've been trying to move honestly for months now. It's just because with me being self-employed and like the requirements of places, it's
Okay, but you can't just sit there and have damages increase.
I agree with that. That's why I made the landlord.
Because it's the law. You have to mitigate those damages. So you're telling me we're trying to move. I mean, the last time I was here. Okay, so last time we were off. I don't know that there was an issue regarding mitigation because there were still people in the premises.
Correct. But from the mold specialist, he could have serviced the property if just the people were out. Because he said he would even have to remedy, the items that are in the rooms too, and see what's savable and what wouldn't be.
So what does that mean?
Like he could come in and remedy the entire property with just the people being out.
Right. That doesn't seem to necessarily cut in your favor. Does it?
I mean, I don't know.
So okay, let me ask it this way. Why didn't the mold specialist come in and remedy?
Because we were still in the property.
Okay, so then the reason things did not get corrected is not anything having to do with the plaintiff. It has to do with you. That's what I'm talking about, the mitigation.
No, the litigation or the remedy thing was just brought an issue. They just had this done probably within the last month. The mold has been going on for almost a year now.
Right, but you can't sit, there's mold.
Right.
At some point you realize that there's some damage to you occurred. Right?
Right. But hypothetically, yes. We haven't been mold tested yet, but I understand you.
You did. At some point, the kids have to get moved out of their room. Right?
Right.
When did that happen?
The beginning of last year.
Okay. So at that point, let's just take that one. You may have even known before that. Beginning of last year, you know that there is a problem.
Mm-hmm.
Right?
Correct.
So you can't, and this is what I'm talking about in terms of the idea of mitigation. If you had said at that point, okay, we're all leaving here, we're going to a hotel. Fine. But you can't then sit in that circumstance and then say to plaintiff, well, you're going to have to pay us for all of this because we're sitting. You follow me?
To a point, yeah, I do.
Okay, what part don't you understand?
I mean, when we brought the issue up, I mean, to me, it should have been taken care of right then and there. And we
That
went,
may be true, but you can't then just sit and let the circumstances exacerbate itself and then claim everything in the world is plaintiff's fault.
well, I mean, I'm just a renter there. I don't feel like it's really my obligation to take care of mold or something that's out of my control.
I'm not even saying that. At the beginning of last year, at some point, you knew there was a problem significant enough that you moved the kids, right?
Correct.
So at that point, even if just for the sake of the kids,
It would have been better if we just all moved. I agree with that.
if you just moved someplace else, let's say you had gone to a hotel down the street, and then you're stuck in the hotel down the street because then at that point the landlord won't fix it. You've in a sense mitigated your damages to the best that you could because you've done something because as you're claiming the landlord didn't do it. Right? But that's not what happened here. What happened here, it seems to me, is you continued to stay in a situation that may have then increased loss for you guys. Right?
Yeah.
Well, you can't do that.
I got you.
So part of the problem, and one of the reasons I bring that up, is because you're claiming, it seems to me that some of the stuff you're claiming, I don't know when that was damaged.
I got you.
Put it another way, if you had said, this place is doing whatever, it's probably damaging all of our stuff, and you guys get yourselves out, you move to a hotel, you then get your property out as best you could, put it in storage, and then say, Mr. Landlord, you need to fix this. That's a whole different ballgame.
I got it.
But that's not what happened here. In fact, the mitigation, so, and again, even at this point, right now, as we sit here today, you still haven't vacated the premises. My point to all of that is, and I just bring up the questions, quite frankly, that the court would be asking about the value of the property. What did you purchase it for? You know, if I had to decide this case, I have to first of all know that the property existed. Put another way, you can't all of a sudden claim landlord's responsible for the diamonds that fell through the floor because they didn't fix the mold and there was a floor, and so now the diamonds are gone. Same thing with the dresser. I have no idea whether it was there.
No, I understand.
Presuming that there would be one, but I don't know. Then it's going to be the condition of that dresser. So that if it was just a cardboard box that we called a dresser, that's a whole different ballgame than if I've got something that
Real fancy or
$1,000 dresser. It's a whole different ballgame.
I understand.
But that you need to understand that this is your counterclaim and you're going to have to show that to the court. Right? On top of that, that's where it kind of gets to this mitigation issue. And that's what I want you to understand is that, and I'm just going to use the dresser. If I know that there's damage that's occurring to the dresser, and let's say I know it a year ago when you moved the kids, I can't then just leave that dresser there to presumably get more damage and then blame the landlord.
I get where you're coming from.
If I could have, let's say this dresser was $1,000 dresser, if I can get the dresser out a year ago, do some remediation on it, clean it up, and now it might only be worth $800. Okay? Then maybe you can go to the landlord and say, yeah, there was about $200 of damage that occurred. That's very different than the same scenario. I had this $1,000 dresser. I just leave it there
And let it get
and
worse.
just let it go to zero where I can't do anything with it. And then say to the landlord, you owe me $1,000. Right?
I get you 100%.
The other thing that you're going to have to realize is and I don't mean this badly, but it's just a state. Every man's junk is their treasure, right? There's stuff in my house that has a great deal of value to me. It has no value to anybody else. I don't know why, but it just doesn't.
You're correct.
So some of the stuff really, in all honesty, when you're talking furniture that's been used,
Yeah.
almost can have no value in a lot of ways. They're very de minimis value. Carpeting, you put carpeting down, paid about $400. By the time somebody starts walking on that carpeting is not worth $400.
What you pay, right?
Right? Then it's going to depend on what was the year rating on it? How long was that carpet supposed to last?
Right.
What was the damage? And then understand, you're then going to get into that issue of mitigation. Could you have taken that, once you know that there's a problem, could you have taken that carpet out to preserve it in some fashion?
Gotcha.
You follow me?
Yes, sir.
Now, what's the other part of these damages you're claiming?
The bulk of it is just like the health risks that were presumed to the premises that
Okay.
anyone could have really gotten sick.
All right. So here's what's going to happen. Here's what's going to happen. You can go get mold tested.
Right. Yeah. Once we're out of the premises, we already planned on doing that.
Okay. So what are you claiming came out of this for all of it?
I mean, we don't know if anything, but I mean, I've been coughing like a lot more. I mean, my kid's been.
Okay, welcome to the land of COVID. Go
Right.
ahead.
But my son's been, same thing, getting a lot more sicker than often. I mean, I can't really prove that it was because of the mold.
Okay, but listen, that's what you're going to have to do. I mean, if you're telling me that the landlord's responsible for that, okay, that's what you're going to have to show the court, which is going to require medical testimony. It's going to require a whole lot of other things because and I just want you to understand what you're doing. Even if you go get mold tested, and a doctor comes back and says, here's something in your system that we think is abnormal. You got to get that doctor here to testify. They got to have a basis upon which they're doing, of which they're coming to that conclusion, right? Let's say you're successful in doing it, right? You're then going to run into that problem of mitigation. Because then did this problem, presuming that there's an issue, did this problem happen in the last 6 months? Did it happen a year ago? Do we not know when it happened? All of that stuff would have to be pinpointed. And if they say, well, this would have been something that would have developed for a year, and just this constant sort of barrage of mold spores is what caused this. Well, then we get back to the thing a year ago. When you know the kids are being moved, why didn't you move yourself? And can I fairly hold the landlord accountable for that, for what may be that issue, when you didn't protect yourself?
I got you.
There is then going to be this issue. So, because I want you to be clear on what you're facing and what you're going to have to show the court. There's going to be an issue of you came up with a number. Don't know where you came up with that number, but also as to whether or not legally you would be entitled to that, because this is really a contract case. So there's that huge legal issue that is also going to be out there. You follow me?
Yes, sir.
So what I'm going to do is, I had this set for final settlement conference because I was hoping that we could probably get this, but I mean, things were taking their own turn wherever, so it didn't work out as I planned. I'm just going to go to, you know what I'm going to do? No, I'm going to still give you the February 23rd date. That's really